This is part 31 of Don't Ever Buy One of These Clayton Manufactured Homes. Because these people are snakes, this entire industry is corrupt to the core, and we want the world to see what's going on. So in our last video, which was part 30, we were documenting some of the fraudulent inspection report from the criminal Vice President of NTA, Erica Tampax, who was not supposed to attend this inspection in the first place. We also showed you an email that we received from the worthless Texas Attorney General Ken Paxton on April 22nd, 2022, where he writes, "Please understand, the role of this office is to advise and represent state entities and interests as specified in the Texas Government Code under Texas law." Then he writes, "The policies and procedures of the Texas Department of Housing and Community Affairs, TDHCA, are developed and overseen by the administrators of that agency and are not subject to review by the Office of the Attorney General. You may wish to continue working with the TDHCA regarding your complaint." First of all, the TDHCA is one of the agencies we have a problem with. So I guess they get to investigate themselves. Who does that sound like? Then he writes, "Ultimate oversight of state agencies is maintained by the Texas legislators. You may wish to contact your legislators regarding your concerns." And then he no longer tells us to contact the Parker County District Attorney Jeff Swain. Instead, he tells us to contact the State Bar of Texas, where he writes, "The Legal Access Division of the State Bar of Texas can suggest legal aid organizations in your area that might be able to help you with your civil legal matter and some criminal legal matters." We filed complaints with the State Bar of Texas regarding what the Texas Attorney General Ken Paxton and the Parker County District Attorney Jeff Swain were telling us. And this is what we had written regarding the Texas Attorney General Ken Paxton. "We are writing to inform you what the Texas Attorney General Ken Paxton and his office are providing as guidance to the Texas consumer who write to his office. We opened a consumer complaint with the Texas Attorney General's office in March of 2020 in regards to the Clayton manufactured home we purchased. We received a case ID number and each correspondence email that had been sent to the Attorney General, the case ID had been referenced. And on October 16th, 2020, we received a response from Mr. Paxton and his office with the following guidance. 1. The ultimate oversight of state agencies, such as the Texas Department of Housing and Community Affairs Manufactured Housing Division, is maintained by Texas legislators. In Texas, the county or district attorney has primary jurisdiction to pursue alleged criminal violations of the law. They are granted extensive discretion in determining which cases will be prosecuted and whether or not those cases will proceed before a grand jury. This office can assist with criminal investigations and prosecutions at the request of the local officials. You may wish to share your concerns with the local prosecutors." So we contacted the Parker County District Attorney, and this is what he told us. The Attorney General's office could investigate a case and refer it to us, as they are also organized in a way that would allow them to do so. So the Attorney General tells us to contact the District Attorney, and the District Attorney tells us that the Attorney General's office could investigate this case. So I guess now we know why Clayton Homes and the Texas Department of Housing and Community Affairs Manufactured Housing Division have gotten away with this crap for so long, huh? After a year and a half and hundreds of emails, on April 22nd, 2022, we received another response from the Attorney General's office. And not only did this response contradict itself in the 3 paragraphs, his website states that Mr. Paxton is the Chief Law Enforcement Officer of the state of Texas. And one of his many duties are protecting Texans from fraud, waste, and abuse by enforcing consumer protection and antitrust laws. The below response from Mr. Paxton's office contradicts this. Mr. Paxton's office advised us the duties were to represent and advise state entities and interests in the Texas government code under Texas law. Then on the next paragraph, he tells us the Texas Department of Housing and Community Affairs are developed and overseen by the administrators of that agency and are not subject to review by the Office of the Attorney General. Then on the next paragraph, his office states that the agencies are maintained by the Texas legislators. So, does the Parker County District Attorney's Office have primary jurisdiction over this? While your office represents and advises the state entities? Or does the TDHCA get to police themselves? Or do the state legislators police them? Or are you the Chief Law Enforcement Officer for the state of Texas? So, do you think the Attorney General's protecting the consumer, or do you think he's protecting Clayton Homes? So, I wonder if the owner of Clayton Homes, billionaire Warren Buffett, donated to the Attorney General's campaign. We have yet to receive a response from the State Bar of Texas, and we're not holding our breath. We had sent a 10-page email to both the Attorney General and the Parker County District Attorney that document multiple crimes perpetrated by Clayton Homes, the attorney of Clayton Homes, the Texas Department of Housing and Community Affairs Manufactured Housing Division, and NTA had committed in this case. And the Parker County District Attorney is the only one that responded to this email. And this email and his response were sent to the State Bar of Texas. And this is his response, where he writes, I've received and read both of your emails. I wanted to let you know that in Parker County, as the majority of counties in Texas, we have both a county attorney's office and a district attorney's office that prosecute criminal offenses. Our office, the district attorney's office, only handles felony offenses. The county attorney's office handles all the misdemeanor offenses. In reviewing the information that you provided in a couple of your YouTube videos, the majority of the issues which you complain are either not criminal in nature. In other words, there are civil but not criminal remedies within the statute, or are misdemeanor offenses which need to be directed the county attorney's office. The one exception to which I noted was a concern about tampering with a governmental record. The record in question, upon which you state that a false statement was made, is not a governmental record. It is a record made involving private parties, specifically you or Clayton Homes or related non-governmental parties. I also wanted to let you know that neither our office nor the county attorney's office initiate our own cases. The cases that we work on need to go to various law enforcement agencies that work within our county to be investigated. Neither of our offices are set up with the staff and capacity to self-initiate investigations. So, if you want to have your case investigated, you would need to make a complaint about a criminal offense to the Parker County Sheriff's Department or municipal police department in which your home is located. Also, the Attorney General's office could investigate a case and refer it to us, as they are also organized in a way that would allow them to do so. Let's take a look at this. So, if you want to have your case investigated, you would need to make a complaint about a criminal offense to the Parker County Sheriff's Office or the municipal police department in which your home is located. But if you look up here, it looks like he's already made his decision. The majority of the issues about which you complain are either not criminal in nature. In other words, there are civil but not criminal remedies within the statute, or are misdemeanor offenses which would need to be directed the county attorney's office. So, contacting the Parker County Sheriff's Office would probably be a waste of time, right? So let's take a look at the next one. The record in question upon which you state that a false statement was made is not a governmental record. It is a record made involving private parties, specifically you or Clayton Homes or related non-governmental parties. This was stated on page 1 of our 10-page email. And this is it. Also, on the Notice of Installation Form T, a state-required document within our contract, it shows that the general manager of Clayton Homes, Jeffy Levy, claimed that he was the licensed installer, which states that I verify that I am a licensed installer, that I am responsible for the installation described, and that the information supplied is true and correct. Executed the 16th day of August 2019. Mr. Levy signed and printed his name on this document. Mr. Levy was not the licensed installer and was not the one that installed the home. This is a violation of Section 37.10, tampering with governmental record. So the district attorney tells me that it is a record made involving private parties, specifically you or Clayton Homes or non-governmental parties. And here is the document. This is page 2 of Form T, where Jeffy Levy, the general manager of Clayton Homes, states that he verifies that he's a licensed installer, that he is responsible for the installation described, and that the information supplied is true and correct. Executed the 16th day of August 2019. Jeffy Levy signed his name that he's the licensed installer, and he also printed his name that he's a licensed installer. Jeffy Levy was not the licensed installer, and he was not the one that installed this home. And this is page 1 of 2 of Form T, and this is absolutely a governmental record, and it's the Texas Department of Housing and Community Affairs Manufactured Housing Division's governmental record. This was also on page 1 of our 10-page email, which states, there are 46 inaccuracies within our contract with Clayton Homes. One of these stating that our home is 2,244 square feet, and our application for statement of ownership, which is a required document by the state of Texas, states the same. The executive director of the Texas Department of Housing and Community Affairs Manufactured Housing Division, James R. Hicks, signs his name to the original statement of ownership, which claims the house to be 2,078 square feet. These are both incorrect. This home is actually 1,942 square feet. And here is our application for statement of ownership, which states this house to be 2,244 square feet. Here is our original statement of ownership, where James R. Hicks, the executive director of the Texas Department of Housing and Community Affairs Manufactured Housing Division, states that this house is 2,078 square feet. These are also falsified government documents. How come the district attorney didn't say anything about these? So, the executive director of the TDHCA MHD, Jimmy R. Hicks, knew that our application for statement of ownership was wrong because it stated that the home was 2,244 square feet. He tells us on our original statement of ownership that the house is 2,078 square feet. So how come Jimmy R. Hicks did not send back our application for statement of ownership when he knew it was incorrect? Probably because he does not know how to calculate the square footage of these homes either. You cannot add the porch to the square footage of the house. And it says so right here. Accordingly, HUD interprets Statute 3282.8G as follows. In calculating the square footage of the home, measurements shall be taken on the exterior of the home. The square footage includes all siding, corner trim, and molding, storage space, and areas enclosed by windows, but not the roof overhang, Mr. Executive Director. That means the porch, Mr. Executive Director. We paid $118,000 for this house, and these are crimes. So on the very first page of our 10-page email, we've already documented 2 falsified government records that we can absolutely prove. So how come the Parker County District Attorney tries to tell us that these falsified government documents are not crimes? How is anybody supposed to get a fair trial from this district attorney when he does stuff like this? And here is page 2 of the 10-page email. And up here it says, Jeffy Levy ordered an installation inspection from the Texas Department of Housing and Community Affairs Manufactured Housing Division on October 8th, 2019. The installation inspection was conducted on October 14th, 2019 by State Inspector Derek Scroggins. Mr. Scroggins was untruthful in 8 out of 10 items in his report, and we have video evidence that back up this claim. And this is State Inspector Derek Scroggins' installation inspection report that was conducted on 10/14/2019. And this is an easy one. You see right here, number 8 says skirting, new home, checked okay. So let's just shoot forward to January 15th, 2020, and let's see if skirting's there. This was the first consumer complaint inspection conducted by the Texas Department of Housing and Community Affairs Manufactured Housing Division. This state inspector is tough guy Jimmy Turner. And this state inspector is lying Derek Scroggins, and over here is the invisible skirting. This is also a government document that Mr. District Attorney closed his eyes to. Then on this same page, Mr. Scroggins said he came back to the property on November 8th, 2019 to re-inspect. We can assure you this did not happen. Mr. Scroggins then states that he had deleted the notes and pictures to make room in his work cell phone. Per Texas State Audit of the Regulatory Activities at the Manufactured Housing Division dated October 2019, Report number 20-002, page 6, states the following. Clarify in a field bulletin to staff that any documentation related to deviations found during an installation inspection must be included with the permanent record. So, Mr. Scroggins deleting the notes and pictures to make room in his work cell phone is a problem, right? So on November 25th, 2019, we hired Hargrave Law Firm to write a demand letter which states both Clayton and Southern Energy Homes expressly promised that the home would be free from defects in material or workmanship and had incorporated this promise into the sale of the home. The Blanks have incurred months of emotional distress attempting to have their home repaired, and in exchange for the purchase paid to Clayton, they have received a manufactured home riddled with defects. So on December 18th, 2019, the attorney of Clayton Homes Wells sends a response where he writes that we have a wrist-wringing emotional demand about having allegedly received a manufactured home riddled with defects is not only grossly overstated, it's factually incorrect. Mr. Wells had never been to the property and would have no first-hand knowledge of these details. Mr. Wells also accuses Mr. Blank of having threatening, vulgar, abusive, violent, and racist behaviors, even though Mr. Wells had never met nor spoken to Mr. Blank. This is a violation of 4.04. Respect for rights of third person. In representing a client, a lawyer shall not use means that have no substantial purpose other than to embarrass, delay, or burden the third person. And Mr. District Attorney said nothing about this. And on this same day, Mr. Wells ordered the first consumer complaint inspection from the Texas Department of Housing and Community Affairs Manufactured Housing Division and incorporated this letter. And on January 10th, 2020, Mr. Wells charged Clayton Homes $952 for various emails and telephone calls involving clients and Inspector Jimmy Turner regarding TDHCA inspection. And our 10-page email states this on page 3. This was 5 days prior to the first consumer complaint inspection, which was conducted on January 15th, 2020. And this is what we wrote. On January 10, 2020, Clayton Homes attorney Mr. Wells noted various emails and telephone calls involving clients and Inspector Jimmy Turner regarding the Texas Department of Housing and Community Affairs Manufactured Housing Division inspections. The Blanks were unaware of these communications. What do you suppose they were talking about? This inspection was conducted on January 15, 2020 by the Texas Department of Housing and Community Affairs Manufactured Housing Division. This inspector was State Inspector Jimmy Turner, who was accompanied by 9 other people unbeknownst to us. This inspection was captured on video in its entirety. This video captured Inspector Turner lying and colluding with the service manager of Southern Energy Homes, Charles Grimsley, on multiple occasions. Per Section 1201.356. Report and Order Amendment Compliance. The report shall specify each of the consumer's complaints. Section 80.73. Procedures for handling consumer complaints. The person conducting the inspection shall inspect all matters relating to the home and or the installation of the home set forth in the complaint and any other item raised at the inspection. Mr. Turner orders 6 warranty items for the manufacturer, the retailer, and the installer to correct, while failing to disclose 62 videoed and documented items we had expressed our concerns about. Some of these items were severe and compromised the safety and structural integrity of the home. This is a violation of Section 39.02, abuse of official capacity. A public servant commits an offense if, with the intent to obtain a benefit or with the intent to harm or defraud another, He intentionally and knowingly violates a law related to the public servant's office or employment. So, Mr. Parker County District Attorney, this is also a government record. This is not some skateboard we bought from Walmart. This is our home, and we paid $118,000 for this home. And this fraudulent state inspection report makes it a felony. So let's see what else was on page 3. We continuously and repeatedly emailed the Texas Department of Housing and Community Affairs Manufactured Housing Division in regards to the conduct of Inspector Turner. So on May 27, 2020, the executive director of the Texas Department of Housing and Community Affairs, Jimmy R. Hicks, orders Eric Franklin to open a new consumer complaint inspection. And this is what he writes. Eric, see below email from Mr. Blank. I'm sure you've already seen a copy before, even though Mr. Blank has not filed a complaint on the required form or online. As a courtesy to Mr. Blank, please open a new consumer complaint regarding his home. Also, please get with Bradley to assign new inspectors to the complaint. I would suggest we send 2 of our most seasoned inspectors, maybe Howard and Randall. But before this new consumer complaint, beginning on June 1st, 2020, the attorney of Clayton Homes, Bent Wells, had multiple communications and conference calls involving State Inspector Howard Delk and the Vice President of NTA, Erica Tompax. These conference calls included everybody but us. So State Inspector Howard Delk's inspection was conducted on June 17th, 2020. And now we have this inspection on video in its entirety. This inspection was conducted at the peak of the coronavirus pandemic. And the governor of Texas had ordered a mask mandate and a social distancing mandate. Unless you work for the state of Texas, I guess, huh? Inspector Delk ordered 9 other people to accompany him to this inspection. Inspector Delk ignored the mask mandate and the social distancing mandate. This video captured Inspector Delk lying while colluding and conspiring with Mr. Tompax, the Vice President of NTA and the Service Manager of Southern Energy Homes, Charles Grimey, on multiple occasions. And just like Inspector Tough Guy Turner's report, per Section 1201.356 Report and Order Amendment Compliance, the report shall specify each of the consumer's complaints. So now we're on page 4. Inspector Delk orders 7 warranty items for the manufacturer, the retailer, and the installer to correct while failing to disclose 58 videoed and documented items we had expressed our concerns about. Some of these items were severe and compromised the safety and structural integrity of the home. This is a violation of Section 39.02, Abuse of Official Capacity. A public service commits an offense if, with the intent to obtain a benefit or with the intent to harm or defraud another, he intentionally and knowingly violates a law relating to the public servant's office or employment. Discussing Delk's report is also a government record that the Parker County District Attorney failed to address. Also on page 4, we informed him that Mr. Tompax, the Vice President of NTA, was retained by Clayton Homes lawyer attorney Brent Wells on behalf of Clayton Homes. But the HUD label that is affixed to the side of the home bears the insignia NTA. This means that NTA LLC inspectors inspected this home during construction. So NTA is the HUD Accepted Production Inspection Primary Inspection Agency, the IPIA, for this home. And it is a violation of HUD 24 CFR 3286.551, which states the inspector must be independent of the manufacturer, the retailer, the installer, or any other person that has a monetary interest. So the vice president of NTA, Erica Tompax, cannot be retained by Clayton Homes liar attorney Brent Wells and be the IPIA for this home at the same time. This also violates statute 137.63, engineer's responsibility to the profession. Exercise reasonable care or diligence to prevent the engineer's partners, associates, and employees from engaging in conduct which, if done by the engineer, would violate any provision of the Texas Engineering Practice Act, General Board Rule, or any of the professional practice requirements of federal, state, and local statutes, codes, regulations, rules, or ordinances in the performance of engineering services. Mr. Tompax's inspection was also captured on video in its entirety. Mr. Tompax was videoed taking multiple photographs of the same item at slightly different angles, then submitting the ones that best suit Clayton Homes' narrative. Then on November 30th, 2020, Mr. Tompax emailed the attorney of Clayton Homes, Brent Wells, regarding questions on the structural wood components of the home. NTA are the leading authorities for these homes and should not be asking Clayton Homes attorney Brent Wells about structural wood components, unless the report was being manipulated, correct? So now we have a pretty clear picture of what's going on, and we went on the offensive and started bombarding anyone and everyone with emails and videos that we thought might be willing to help. Clayton Homes liar attorney Brent Wells, he was not happy about this, and on September 8th, 2020, he sent us a demand for arbitration. And this hearing was scheduled for January 21st, 2021. This case was to be heard by Kyle Gooch. He's a board-certified construction lawyer, Texas Board of Legal Specialization. But we did not attend nor respond to this arbitration. The two consumer complaint inspectors from the Texas Department of Housing and Community Affairs Manufactured Housing Division knowingly and intentionally withheld crucial damages and defects from their reports. There cannot be arbitration or civil matter without first a criminal matter. So this arbitration proceeded without us. So this is page 8 of our 10-page email. And this is the final award of the arbitrator, which states, this dispute arises out of the purchase and sale of a manufactured home to the respondents, manufactured by claimants Southern Energy Homes and sold at retail by claimants Clayton Manufactured Homes. Now here's where it gets good. Respondents filed a consumer complaint with the Texas Department of Housing and Community Affairs, raising issues and complaints concerning the quality, construction, and installation of their manufactured home. But we did not file for the first consumer complaint. That was Clayton Homes liar attorney Brent Wells. Then on this same page, a second consumer complaint case was filed by respondents before the Texas Department of Housing and Community Affairs Manufactured Housing Division. Once again, allegations were made concerning defects in the home. Experts and inspectors from the Texas Department of Housing and Community Affairs Manufactured Housing Division inspected the home and issued reports. So we did not file for the second consumer complaint either. That was ordered by the executive director of the TDHCA MHD, Jimmy R. Hicks. And this expert witness is Erica Tompax, the vice president of NTA, who was not permitted to attend this inspection in the first place. Also, Clayton Homes lawyer attorney Brent Wells failed to submit Form T within our contract that states Jeffy Levy, the general manager of Clayton Homes, was the licensed installer. He also failed to submit the installation inspection report from State Inspector Derek Scroggins. So on August 19th, 2021, Mr. Wells submitted the confirmation of arbitration award as a judgment to the Honorable Eric Moy of the 14th Judicial District. So Mr. Wells lying to the arbitrator is one thing, and then submitting the evidence he knew was incorrect to this district judge is a whole new problem, right? So in this 10-page email, we laid out 7 crimes that the Parker County District Attorney flat out ignored or gave us incorrect information. And this case should have advanced the careers of both the Attorney General and the Parker County District Attorney. Instead, this case should end their careers. And the reason it's taken so long to produce this video is because the list we send this stuff to got 1,000 times bigger, and a lot of these places you have to physically mail this information to them. So we're going to have to wrap up part 31 of our Never Buy a Clayton Manufactured Home. And our videos are up to 177,657 views with 456 subscribers. So remember to like, share, subscribe, and leave a comment to all of our videos. Thanks for watching. See you in a couple weeks.